because we have Wyatt with us, and he works for the One BC Caucus, and we've got Keith Wilson, who is a very careful person who pays attention to these sorts of things, and of course his law background. It's DRIPA in BC. So a lot of people are mistakenly, I think, Keith will walk us through this, attributing the Cowichan land claim craziness, where all of a sudden everybody's land titles are in jeopardy after an Indigenous land claim. They're attributing it to DRIPA, which is the BC version of the UN Declaration on the Rights of Indigenous People. That means that everything has to be considered through an Indigenous lens and potentially Indigenous land claims. But Keith corrects us by saying that's not what happened. The two things are unrelated in the Cowichan case. So please walk us through this.
Yeah, I mean, BC's in trouble.
Yeah.
First we have the Cowichan decision that came out in August that says if you own land, if you own a business, if you own a home, and it's subject to a land claim from a First Nations, and they're able to establish Aboriginal title, that Aboriginal title trumps your freehold title or your fee simple title granted by the BC Crown. And in fact, the court said in Cowichan, remarkably, shockingly, that your title is invalid in the face of the Aboriginal title. And because of all of British Columbia, essentially less 5%, primarily on the southern portion of Vancouver Island, is subject to outstanding land claims. I put up a website link in one of my tweets where you can go to the BC Treaty Commissioners and pick your land, and you'll see that Vancouver's actually got 5 or 6 overlapping land claims. So that decision in Cowichan is a byproduct of the 1973 Calder decision that I studied back in law school over 30 years ago, which led to another Supreme Court of Canada decision and another Supreme Court of Canada and another Supreme Court of Canada decision overlaid with Section 35 of the Constitution that establishes charter rights. The judge in Cowichan added them all together and said equals Aboriginal title trumps fee simple title. Did not rely on UNDRIP or DRIPA. In 2020, the federal government through Bill C-15 and the BC government through some bill decided to adopt the United Nations Declaration on the Rights of Independent of Aboriginal peoples, Indigenous peoples, and make it law. And I actually have been retweeting my tweets from 2020 because I predicted what's happened, which is last week, the Court of Appeal of BC released a decision applying DRIPA and UNDRIP and said mining claims invalid, essentially, because First Nations have veto. And the problem with UNDRIP is that I think it's clause 32, if I'm not mistaken, gives First Nations communities a veto on any land uses or resource development in their area. British Columbia applied that UNDRIP and made it the law of the province and made it the paramount law of the province, which now means any mining claim that didn't go through it and comply with DRIPA is invalid, and that's what their Court of Appeal ruled. So they're both huge problems. No. One's easy to fix, which is the BC legislature can repeal DRIPA, and that will make it easier for resource development and undo the effect of Friday's Court of Appeal decision. But it will not touch the Cowichan problem. The only way that can be fixed, as far as I've been able to figure out, is one of 3 ways. If you own land in BC, move, get out of the province while you still can. The other option is for Section 35 of the Constitution Act to be amended to reduce Aboriginal rights. I don't see that happening. And the third option is for the BC government to enter into land claim settlements, which will be of billions, if not trillions of dollars that will have to be paid for by the taxpayers of BC. So
Wyatt Claypool, is the NDP going to do that, or what is going to happen?
Are they going to do anything?
Yeah.
Well, the One BC party is the only one that actually wants to push to actually make changes to Section 35. I would agree with Keith that would be a very difficult thing to do, but someone has to start advocating for it to normalize what is a very common sense change. because obviously it's screwed up so much in Canada, including for First Nations people, to have Section 35 in there and effectively acting as if there is a collectivist nation living within Canada that doesn't interact with Canadian law like everyone else does. And this is also why there's so much poverty for First Nations people, is it treats them like a collective entity. The one thing I did want to talk about when it comes to the Cowichan decision, when it comes to UNDRIP and DRIPA, they didn't specifically reference DRIPA in the decision. And you are right that it actually doesn't have anything specifically to do with DRIPA. It actually might have more to do with UNDRIP itself, because in the decision, the judge referenced Section 8.1 of the Interpretations Act, which says that UNDRIP, not even DRIPA, but UNDRIP has interpretation force over everything else, that you effectively should always read that above everything else that's done in any court case. That simply, like, Indigenous rights, Indigenous everything is always going to have like a higher value, rather than saying two competing claims and which one has more legitimacy. The Interpretations Act says the Indigenous claim always has more legitimacy.
That's crazy. It's like Canadian sovereignty just doesn't exist in British Columbia anymore.